The topic of today's podcast is federal employees accused of discrimination. What should you do? Let's say you are a supervisor, a manager at a federal agency. This happens all the time. In fact, the higher up that you are in that agency, probably the more of these discrimination or hostile work environment complaints you're going to get. And by the way, that doesn't necessarily mean that you've been doing anything wrong necessarily. That just is what happens at these things because you're in a management chain. So ordinarily, people think, well, why would I need my own attorney? I have the agency lawyer. I mean, the agency lawyer is contacting me and helping me out here and everything like that. Well, the first thing you have to do is understand that the agency counsel is not your counsel. They are going to do what's in the best interests of their client. And who is an agency's lawyer's client? It ain't you. It's the agency. You have to really understand that. I represent 3 managers right now at Social Security Administration, or SSA, more commonly known, somewhere in the United States, and it doesn't really matter where. And they're in a management chain accused of lying to an EEO investigator. Okay, now this seems as a bizarre story, but it's really worth taking a solid look at here. Once upon a time, there was a Social Security Administration employee who contended that his management chain was harassing him. They put him on a performance assistance plan. They didn't let him telecommute. They didn't let him work up his schedule a certain way. This person had some sort of panic attack type of thing. And basically what this amounted to is an employee who was basically incompetent and later quit the agency. But he did bring these claims against his management chain. And SSA, they investigated these 3 managers and they cleared them and they found there was nothing wrong. They didn't break any law. They didn't harass anybody. They did nothing to this guy. Okay. The alleged victim then sends an email to SSA's national, some sort of human relations department or human resources department in Baltimore, contending that these managers lied to, of all people, EEO investigators, and that he's got the proof of that, and he's got these tape recordings. He secretly recorded one of the managers and says, now just putting aside whatever state laws there are about unauthorized recordings, but just putting that aside, he has the recordings, and the HR department says, whomever it was says, yes, wow, that's really something. Very, very critical that we investigate this, that we investigate the lying. Send me the recordings, and we'll go through them, and we'll investigate this. And he does that. And the HR department, they listen to these tapes, and they launch another investigation against these managers. And their contention is, and I even got this at a deposition testimony when I deposed this HR person, was that clearly she believed she was doing the right thing, that we have to protect people from retaliation and harassment, and we have to crack down on liars. Liars to the EEO investigators, and during the discrimination process, what's worse than a discriminator? Someone who's not only a racist, but he lied about it. That goes right to the heart of the system and what we have to protect, and this is what we're doing. Now, this is a really, really big problem, because if you look at Title VII and you look at the language of Title VII, it says that an employer cannot retaliate, among other things, someone who has made a charge. The key is an employee who has made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing. And the words "in any manner" are very critical. The classic case that I'd like to talk about is a case, Guy against Johnson. It was decided by Judge Randolph Moss in the Federal District Court, District of Columbia, who I happen to think is one of the best judges that I have been before, and I have been before many. This is a very well-thought judge, very rational, makes very good decisions, and is very analytical, which is what you want in a judge. You want someone who really studies things before just simply making a decision. And Judge Moss, he goes into this case, and the case was a woman brings a case for some sort of discrimination against the Department of Homeland Security, and the case goes before an EEOC judge, goes to hearing. She loses, and the judge writes words to the effect, in his opinion, I didn't find the plaintiff, the person who brought the suit, I didn't find the plaintiff credible. Okay, what does DHS do? They fire this lady. Why do they fire her? Not for bringing a case, because that would be retaliation. They fired her because if the judge didn't believe her, that means she's a liar, and we can't have liars working here at the Department of Homeland Security. We can't trust you, therefore you are fired. Judge Moss granted summary judgment, which means he said the case doesn't even go to a trial. Not for the Department of Homeland Security, for the employee. Because Judge Moss says, and he relies on several cases, a number of them. One is the Petway versus American Cast Iron Pipe Company case. That's a Fifth Circuit case. Another one is Glover against South Carolina. That's a Fourth Circuit case. And Judge Moss goes through the analysis, and Judge Moss says that this is a classic case of an employee who makes a charge and testifies and participates at a hearing and is protected under Title VII. It doesn't matter that the employer thought that the person lied. Okay? What matters is she participated in that activity. She is protected. Now, the Glover case deals with someone accused of discrimination and accused of lying during a deposition. And in Glover, there was an employee supposed to testify, does testify at a deposition. The employer reviews the deposition transcript and finds that the testimony that she gave was unresponsive, uncompelled, gratuitous, meaning you weren't telling the truth. And I'm firing you for not telling the truth. And the court in the Fourth Circuit says you can't do that. You can't fire someone based on or take an action against him based on your perception that the person wasn't truthful during an EEO proceeding. And the reason for that is because of the language that you are participating in any manner. Now, the company argues, well, what are we supposed to do? This person discriminated against someone else. Can't we fire the person for discriminating against someone else? Yes, you can, employer, but that's not what you did here. What you did is you fired the person because you didn't find the person credible at an EEO proceeding. And the case says, it cites the Petway case, that Congress has determined that some irrelevant and even provocative testimony must be immunized so that Title VII proceedings will not be chilled. And it is not for this court to overturn that judgment. Meaning, there may be some provocative testimony. There may be people who did say things that were off the wall or untrue or whatever it was. It doesn't matter. What Congress intended was that these EEO proceedings, these Title VII proceedings, are protected. Meaning, there are going to be cases where someone may believe, like the HR person at SSA, that she's doing the right thing. It doesn't matter. The Title VII participation clause cannot be chilled. And it's not for a court to overturn the congressional judgment. Okay. Now, as this case goes on, and it's still in litigation, SSA argues this minority opinion, okay, and there is a split in the circuits. There is the Seventh Circuit case of Twisdale versus Snow, and it's a 3-page opinion, and it doesn't go through any legal analysis of the Fourth or Fifth Circuits, or certainly anything Judge Moss says. It just basically says that if we protect people who were the witnesses against the guy with the claim, well, then that wouldn't make any sense. Okay, well, guess what? Now, I know this is a little bit counterintuitive, okay? But it is not a judge's job to determine if a law is reasonable. All right, let me say that again. Okay, I know, because it is a little, I wouldn't have known that, but it is not a judge's job to determine if a law is reasonable. All right, now we think it is, just the way the media portrays what the job of the courts is. You know, everything happens at the courts. Protests for or against, you name the issue, whatever it is. Where is it? It's in front of the Supreme Court. Must be. That's what they're deciding. They're listening to my protest, and they're saying my protest is what's going to influence their opinion as to whether they should rule for one side or another. Well, that's not what the Supreme Court does, and that's not what judges do. What they do is they decide two things. A, is such a law, is any law constitutional? Two, if it is constitutional, is it reasonable, not in its own right, but reasonable per the language and intent of what Congress passed as the law? Right, now let me give you an example of this. Let's say Congress passes a law that everybody in America has to eat a certain amount of broccoli every year. Okay, why? Because studies have shown that broccoli is essential in stopping certain kinds of cancer. And the more people eat broccoli, the fewer people get cancer. This will lower everyone's insurance premiums, okay, because my getting cancer jacks up my neighbor's premiums. It's not fair to him, and the healthcare costs are out of control. So here was the idea Congress came up with. Everyone must eat broccoli or pay a penalty. And in fact, on your 1040 tax form, there's a box everybody has to check certifying, yes, I ate my required amount of broccoli this year, and that's what you have to do. Otherwise, you get a penalty. Now, there's some guy. He weighs 400 pounds. He's 35. He lives in his parents' basement, and he says, I hate broccoli. And he doesn't check the box. And the IRS takes away his refund based on the penalty for not eating broccoli, and now he sues. And the case goes to the Supreme Court. This guy's best argument would be some sort of constitutional right not to eat broccoli. Maybe his religion is opposed to it. Assuming there's no such constitutional right to not eat broccoli, it's not the job of the court to decide whether this law was reasonable. It only has to decide what's called a rational basis, which means, does the law serve a legitimate government interest? And the answer in just about every single law is yes, there is. Reasonableness for a judge is whether the outcome is reasonable vis-a-vis the language and purposes of the statute. In this case, the retaliation Title VII clause could have said a complainant who brings a discrimination case or testifies is protected. It doesn't say that. It uses the word employee. And the majority opinion of the courts is that it's reasonable to assume that Congress wanted all participants in a Title VII proceeding protected. And this is the current dispute of law before the EEOC judges, and it has not yet been decided. So what should you do if you're a manager and you are accused of discrimination at a federal agency? Well, the first thing you should do is become a claimant yourself. All right? So, for example, if you're contacted by an EEO counselor and they tell you, we want you to come down here because so-and-so, one of your direct reports has brought a discrimination case against you, you should immediately say to that counselor, I believe that this guy brought this claim against me because of either my race, national origin, whatever it is. And I'm putting you on notice, Mr. EEO counselor, that I am filing my Title VII informal complaint right now with you. So you have that on record. And now that I've done that, I will answer your questions. And this is easy to do because chances are whoever accused you of some sort of discrimination, you most likely have the opposite of whatever that guy is. So, for example, let's say you find out that a Muslim had brought a claim against you for religious discrimination and you're a Christian. So what you should do is immediately file a counterclaim based on religious discrimination the other way. He did something to me based on my religion. He brought this claim. Now, even if your claim gets dismissed, which it probably will, it doesn't matter. You brought the claim to get the protection of this narrow definition of some agencies, okay, Social Security at least, that's saying that the protection is only good for claimants, not for the accused. So once you bring your own claim, you can never be accused of lying to an EEO counselor or investigator. After all, you're a claimant, and all the circuits hold that a claimant does have those rights. Now let's take this a step further. If the agency believes that you, the counterclaim, you, the guy who was accused and brought the counterclaim, that you didn't do it in good faith, can the agency now discipline you for bringing a claim in bad faith? No way in hell. Absolutely not. What are we going to do? We're going to have agencies determining whether people who bring discrimination claims were in good faith or not, and then being disciplined for not bringing them in good faith? Wow, that is going to have a super duper chilling effect on Title VII protections. No way is such a law be upheld. Just not going to happen. Another thing, whether you have a claim yourself, certainly if you have a claim yourself right now, or you're a witness in a claim. All right? Let's say you work with someone and your manager is treating you horribly. The manager is treating you with hostility, which is not surprising because you've sued him. Okay? But the way the government works, he's still your manager. What you should do, okay, is during the course of the proceedings, depositions, the hearing, and particularly if you're an SSA, Social Security Administration employee, and we take cases anywhere in the United States, and on this one case, I think I've traveled to 6 different states, taken depositions, which I've truly enjoyed, but that's a whole other thing. What you should do is you should get the transcripts of the depositions and the hearing. Now, why should you do that? because what you can show is that you have a good faith belief, at least, probably you're right, that your manager lied. Your manager lied to an EEO investigator, to your attorney at deposition, at hearing. You file a claim at SSA's HR department, and you say, so-and-so is my manager. I fear retaliation. Here are the transcripts, and here is where this person lied. And then what these people have to do is, by their own policy, is investigate these people, remove them from their management duties, as they did to my 3 guys, okay? Because, we want to protect against retaliation, so to speak. And voila! You don't have to deal with that person again. He's out of your management chain until this investigation, which takes, 8 months to a year, is resolved. You have just resolved your hostile work environment problem.